issues. Kat, I'll turn it over to you.
Sure, thank you. So like Mita said, this is a pilot program. We get to define what this looks like and how we move forward, which is pretty cool. Getting the first, I mean, it's not perhaps as cool as being the first person on the moon, but it's right up there. We do want to talk about employee rights today. And of course, on that list would be Weingarten, Ohio's version of that. Garrity, I'm going to go ahead and toss Piper in there because I feel like Piper doesn't get enough love from people. And then the right to private representation. Do we have any folks who are in our coffee table today who do both public and private, or are we all on the public side, all on the private side? Where are we? So public, let me see some hands. How about private? Just the two of us, Mita, we'll hang out. It'll be fun. On the public side, like we talk about Weingarten a lot, and I think we use that term as a blanket term for when employees have the right to union representation in meetings. Although if you dive down into the minutia, Weingarten, which is based on the National Labor Relations Board, is a little different from the right of representation in the state of Ohio for public sector employers. I don't know if you all have seen that, or have you all seen where folks just use Weingarten, they just toss that word out and they don't draw the distinction between the federal right and the state right?
You know, Kat, I don't think most people know that that comes out of the National Relation, Board. That, right in and of itself. And that you have to look to your state or your city or your county, for some rule that kind of incorporates that concept.
Yeah, it's Mia, you're absolutely right. That it's the Weingarten right comes out of a case where there's a lady with the last name of Collins who was working for the employer, and there was an allegation that she stole chicken. She put too many chickens in a box and she was walking out with her chicken, and she asked for union representation during the meeting and her employer said no. Matter of fact, they said, not only are we not giving you union representation, but we're going to tell you you're not allowed to talk about this. She ignored them and she went to her union and they filed an unfair labor practice charge with the National Labor Relations Board. And the board dove into Section 7 rights and said the right to representation has to include some right within disciplinary or investigatory meetings. But Weingarten is somewhat limited. It really does have to be where the employee is being questioned and that questioning could lead to discipline, right? So it's not going to be, hey, I need you to go over and clean up that mess in streets and utilities. It's not going to be, we met last week and here is the predetermined discipline. So it is fairly limited and it has to be invoked by the employee, right? Ohio, on the other hand, back into the 80s, CERB looked at this and said, Weingarten is great and all, but it was based on an interpretation of Section 7. And we don't have Section 7, and we don't have the National Labor Relations Act. So ours is a little bit different. And when you go back and look at the CERB case, they draw it more broadly and say that an employee is entitled to have the assistance of their chosen representative, their union, to speak on their behalf in discussions with management when it would be relevant for the employee-employer relationship and when the conversation isn't routine or supervisory or instructional, right? So it is actually broader, which is, I think, something, Mita, that not a lot of people recognize. And if you're on the Google machine, I love the Google machine, and you're researching Weingarten rights, it is a bit narrower, I think, than what we have in Ohio. And I don't know if you all have seen that play out, or we are just so accustomed on the public sector side that we're like, oh, yep, let's bring the union in anytime we're going to sit down and have a conversation with someone that is more than just, I need you to build the widget this way. I don't know. What do you all think? Amanda, do you find that you get drawn into conversations a lot more readily?
So much more. And in fact, I didn't know what you just said. And I sort of just thought it was a state of Ohio. They have such defined procedures that will involve union representatives. And I just kind of figured they must just be super casual, about it.
Yeah.
But
and
you
it's,
might also see that in your collective bargaining agreements, if they have right to representations for other matters other than investigatory interviews.
yep. That's one of the fun things. If you start looking at private sector collective bargaining agreements, they do not have as many employee rights baked into the agreement as we see on the public sector side. Like there is something that the public sector unions have just done. I shouldn't, as a management employer attorney, I should not say they've done a better job, but I'm gonna go ahead and say it. They've done a better job of baking in those rights so that we don't have to stop and consider, all right, which rights apply. It's in the contract. It's just easier to know. But it is a broader. Have we seen issues with people not being included? Have there been any times where you're like, oh, I should have been there and I wasn't? Or is it just something that folks normally do now that, hey, we're going to have a conversation with the employee, we should call the union and make sure that they're there? I will say that one of the things that I have seen come up, and that on the management side we need to do a better job of, is explaining to supervisors and HR folks what to do when somebody invokes their Weingarten rights, right? Because it is something that the employee invokes, said, I want my union here. And when an employee makes that clear request for a union representation, right, we have to choose from three options, right? There's only three things that an employer can do. We can grant the request and then wait for the union representative to arrive, and right, and give them a chance to chat with each other. It's not just they get to walk in the room cold and we're going to start asking questions. They get a chance to chat. We can deny the request and end the interview immediately, or we can give the employee the choice of having the interview without representation or ending the interview, right? So there are some options, but I don't know that on the employer side, we do a good job of educating folks about what do you do when someone asks for a union representative in the middle of an interview, in the middle of an investigatory interview. And part of that is the right to be like, okay, we're just not going to talk. Which I think makes some people uncomfortable, right? Because once you've started down this process, you feel like you have to continue down the process. But you can take a break and be like, someone did a thing, I'm not sure what that is, so I'm going to stop and we're gonna figure it out.
It's interesting, Kat, you mentioned they have three options once it's invoked.
Mm-hmm.
But the fourth option that they cannot consider is to continue the interview without the representation, because that has a legal consequence to
It does.
that.
It does, absolutely. There is a legal consequence that it's, if you remember your criminal law and all of that, it's fruit of the poisonous tree. I've yet to meet an arbitrator who's like, nah, I don't care about Weingarten, and you deny the rights. It radically changes your case. You lose that evidence. You're not going to be able to use the evidence. And you look, as my daughter would say, like a jerk-sickle, right? And the last thing you want to do is look like a jerk-sickle in front of your neutral, because, right, that filters into the brain, and it's a factor that gets weighed if you're denying somebody their rights.
Also, ULP violation, isn't it?
It can be an absolute ULP, because these are the rights that the employee has. And it's hard to go back and fix it, right? It's hard to put that cat back in the bag once it's gotten out. So I think that's training both the union advocates, training the management side folks who are going to be talking to employees so that they know. And even on the management side, I think you have a harder job on the union side, training advocates and training union stewards. But on the management side, if it's just as soon as someone says, I want union representation, stop. That's all you have to do. Stop and pick up the phone and make a call and find out what's going on. I very often say to my clients, at least, that nobody needs to be fired right now, right? Nothing needs to happen right now. Now, there are some obvious exceptions, right? Like there's an axe murderer, like we need to fire this person right now. But how often are we actually dealing with an axe murderer, right? We can take a moment and we can stop and gather, but particularly for frontline supervisors, teaching them stop, just stop, and that's okay, and pick up the phone and make a call, because you can't unring that bell, and it absolutely makes a difference. And you want to make sure that you have it, right? Now, the follow-up question we get is, all right, the union's here, what are they allowed to do? Well, there's no Perry Mason moment happening. There's not going to be cross-examination. There's none of that. But they do have a right, particularly in Ohio, to represent the employee. They can ask a clarifying question. They can consult with the employee. They get to talk beforehand. They do represent the employee. They're not looking at evidence. They're not cross-examining and examining, but they are allowed to be there and they are allowed to participate. Yeah. And I don't know if you all see on the union side of things pushback on that, saying you just have to sit here and be silent. You're not allowed to do anything. And that seems to be a line that sometimes confuses folks as to who's allowed to do what and when and how.
I see that much more in the private sector.
Yeah. It's, you may sit there, you may do nothing else, right? And on the public sector, it can get confusing because, of course, we're not going to talk about lateral hearings today, pre-disciplinary conferences, but what do you get to do for that? And it's just a lot of different things to balance out and to know who's allowed to do what and when. I will tell you that, I mean, all of these rights that we're going to talk about, I'm not going to say I don't care about them. I absolutely care about them, but I do not draw distinctions. So if I'm sitting down with an employee, I'm giving them Weingarten. I'm telling them up front, I'm not waiting for them to invoke it. I'm telling them Garrity. I'm not waiting for them to invoke it. I'm telling them Piper. I'm not waiting for them to invoke it. I'm putting it all in writing, them having them sign every time. So that is never a consideration. It's never an issue that has to be talked about. We never have to dive into the details of should the union have been there? Should it have been given? Nope. Every single time in writing, so that it's just not up for conversation or discussion.
That's the best practice, Kat, for management, right?
But I think it's easier. It just makes things easier and it takes the discretion out of it.
But the actual rule requires the employee to invoke.
The actual rule requires the employee to invoke their Weingarten rights and to ask for union representation.
So how does the union, for their union members here, how do you educate the bargaining unit about what this right is and what it means once they're called back into the supervisor's office? I see we have Linda on the line. Linda?
Hi.
How are you?
Good. I joined a little late.
So how do you educate union members to
I
invoke
think
this
there's
right?
stewards training. I know some unions print up little cards that provide that information. Mostly training.
Anyone else?
I like the cards. I've seen some of those. Amanda, I think some of
That's
your
what I was
units
just going to
have.
say. Especially when we give people their collective bargaining agreements, a lot of times we'll give them a card at the same time, but they're wallet sized. So I think that's the idea, is that you can carry it around with their wallet. And then I tell the people that don't often wear things with pockets that you could also just take a picture of it and always have it ready on your phone.
So what about, even the next requirement is that they have a reasonable belief that this investigation will lead to discipline. How do you measure that? I mean, it's not like what Kat was suggesting. We call all the time, any setting, training, or any reason, right? You call back doesn't mean that you're entitled to a union rep. So how do they acquire an understanding on what situations that they are entitled to representation, as opposed to what situations they are not?
I think a thing that I have seen in practice that works well. I have a unit that has trained their members to ask 2 questions. Does this relate to the terms and conditions of my employment? Could I be disciplined from this? Right? And if the answer to is yes to either of those 2 questions, union rep needs to be there. Right? If it is no to both of those questions, I'm teaching you how to make a widget, or I'm just giving you a friendly heads up, or some other scenario, or you're just a witness to the sexual harassment that happened out on the street, then no union rep there. But I will tell you, practically speaking, if I am interviewing witnesses and they are truly just witnesses to the thing, sometimes depending on the relationships in the bargaining unit, they are more comfortable and more willing to talk to me if their union rep is there, particularly me being an attorney. There are a lot of folks who are like, nah, I don't want to talk to an attorney. Attorneys, they're the devil's work. I don't want anything to do with that. And if I can say, bring your union rep, bring your spouse, right? I just want to know what you saw. That can sometimes put folks at ease. But there is a level of training, right? You do not get a union rep when someone is just teaching you how to use the new equipment, for example.
That's interesting you brought up, Kat, about witnesses, because, sometimes, like I have observed in my arbitrations, the witnesses even having union reps there, because in their own mind, when a situation is presented, they don't know who the employer is targeting. So what's the best practice in those instances?
Oh, and in arbitration, then that gets right tricky. If someone is just a witness at an arbitration and they're represented by the union, then the union theoretically should be there representing someone. Where it gets trickier, and you may have seen this in some of your arbitrations, Mita, is when a witness or someone will show up with private counsel in addition to the union at arbitration. And if it is the grievant, then arguably under Piper, they have the right to counsel, because under Piper, and we haven't talked about Piper yet, but when you are in anything resembling an administrative formal proceeding, Ohio folks have the right to the attorney to be there. But if it's just a witness and they are a member of the union, it's not going to fall up under Piper, which means it falls back to the collective bargaining agreement. And I have yet to see a collective bargaining agreement that does not describe the union as the exclusive bargaining unit representative for the entirety of the union. So arguably, there is no right for that witness to have private counsel. Now, if you look in El Corey, there's this lengthy, I think, section from an arbitrator saying it is a balance. Right? It's letting people feel that they have been represented. It's letting people feel comfortable. And there's always the thought that to deny someone their chosen counsel could lead to things being reversed. To permit someone chosen counsel probably will not. And I don't know, Mita, I'd be interested to hear from the arbitrator's perspective, when you have witnesses show up with private counsel in tow and the union and union counsels there, do you let everyone stay? I've been taken out in the hallway and said, do you object to this person being here? I do not. Have you seen that yet?
I've only had 2 occurrences where that happened, and how I handled it, it's their process. Yeah. So do you have an objection to it? And that's probably why you were taken out into the hallway. Mm-hmm. Do you have an objection to it? If that answer is no, then I don't have an objection to it. And I have not yet to have somebody object to that. Now, if they would object, I think I would allow that person to stay, because I would not want to be reversed on due process arguments.
Yeah.
Off the cuff. When I'm thinking off the cuff is because it was like, you have a right to representation, especially if the claim is for a grievance discipline, not interpretation, because the argument becomes with interpretation that the union owns that contract.
Mhm.
But with a grievance discipline, that discipline relates to specifically that individual. So I think in those cases, I'll be more inclined to leave that attorney at the table.
Yeah.
And I would just defer to, examination at two in that process. Starting with the union first and then allowing the attorney to talk secondly. I think in union discipline cases, I had one where the union, walked away because it was a discipline case. And they chose to have that person there as a private rep. I think they were saying that they would allow it. I think it might have been different.
Hey,
If there was
Mita?
Yes, Gary.
I'm going to speak from my experience as a union advocate.
Okay.
If someone brought an attorney into the hearing, I would always tell them to leave. And because I'm the representative. And I always was concerned when an attorney or anyone else came that for potential charges that of an unfair labor practice that I might have been, or the union would be becoming sued. So it was the union's hearing, even if it was discipline. It was not. I hear what you're saying about the individual, but it's still the union's hearing, and the union and management would have to agree to that person being in there.
Well, that's what I said, Gary. Gary, that's what I said, because with the ULP, that's going to relate back to the union. So
well, that's correct.
I can see the union, being there. That's going to cover the concepts of the contract. But for a discipline case, strictly discipline with no contractual overview, I hear that your concerns as a union, well, this is, we have a contract and we're the representative, so we're going to do that. But I've seen other unions back away from those cases.
It's up to the
Gary
union.
Comes from the post office, by the way.
We always
comes from the post office.
Yeah, it's up to the union, but we always, told our people not to let anybody else come in. Even the discipline was covered by the contract, and it wasn't an individual issue.
Mm-hmm.
But if it was in arbitration, that was our arbitration. That was our hearing, and we only allowed people that were in that we wanted to be in there.
Yeah, Gary, I think you're talking from the postal.
That's all I wanted to say.
Yeah, from the post office perspective, but I don't think that's everyone's perspective on that.
I will say that I work with a union that they will not, it's an either or for them. If you would like to have your private counsel, by all means, we will step out and your private counsel can move forward with this. If you want us to move forward with this process, then it's going to be us through our process.
That's how we try to do ours. We try very, 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 very hard to kind of push the member to make a decision and do one or the other.
Eric, what about any thoughts, Eric? You wish to share?
I know what we train, on certainly is, the other side. Again, it's really the union's decision. We would want them to make a choice one way or the other, ideally. That's kind of usually how we train things. But as far as whether there's legal counsel present or not, that's usually more of a union side issue, though, and something for them to figure out if they want to waive their right of representation there or not. But
Linda?
That's where most of our contracts say something along those lines, that obviously the union, again, is the exclusive representative. They have to waive it in writing. Usually the union has to waive it in writing if they want someone else to represent that member.
But for the union advocates here, are you more likely to waive for contract interpretations or discipline? So I think
Doesn't matter. It'd be the same for both.
So I think as a union advocate, I wouldn't waive on contract because, that's something that we bargained for and we don't want any outside influence.
Oh, that's a really good point. maybe I'm wrong. I could be wrong.
Well, and I
Mike?
think the concern would be that, I mean, Amanda, you know what quality you bring to the table when you sit down to do an arbitration, right? And if someone is going to bring in their brother, sister's, cousin's second child from their first marriage, who's going to be the lawyer on this case for free, like, are they going to jeopardize future interpretations of your contract?
Yeah, and when I think about it that way, I think like, hell no, we wouldn't allow that. Which makes me think that maybe every case that I've had where there has been an attorney involved has been disciplinary.
Mike?
Thanks. And I'll just add my 2 cents. I'm an arbitrator. I'm a relatively new arbitrator, and I haven't had the situation come up in this practice where I've had an outside attorney appear on behalf of a grievant or a witness. But thinking back to my practice as a management attorney, I've seen a number of instances where it's essentially in disciplinary cases, you have individual attorneys showing up alongside union reps. And, there's plenty of examples where there's an either or, as Kat and Amanda mentioned. Either you choose your union rep to move forward, or you choose your personal attorney as your representative. But in the places where I've seen a dual representation case has been where there's some sort of outside liability in the, perhaps in the criminal sense. I'm thinking back to a number of drug testing cases that I did with the municipal police department, where there was the disciplinary aspect and there was a potential criminal aspect. And those individuals typically had a criminal defense attorney. And in those cases, the union had in many cases actually retained that criminal defense attorney on behalf of the member, and would coordinate with that individual to allow them to participate in the questioning of the grievant as well as some of the witnesses. So it's, in my view, I think it's the equitable approach. Mita, you started with that in having a conversation and saying, do you want this person here? And what role are they going to play, if any? That's a question. The first question is posed to both parties, and the second question is posed specifically to the union side, or where you start. And there's a lot of things that go into it. It's, what's the relationships, the parties, what's the tenor of the specific issue that's before you, and so on and so forth.
Thanks.
Hey, Mita,
Yes, Gary?
I spoke as an advocate earlier, but as an arbitrator, whoever shows up to represent, doesn't matter to me. I'm not going to kick anybody out of the room unless someone on the table, management or the union, says this person has no business being here. Then I would have the advocates take them out in the hall and say, what's going on, before I made any decision.
Okay.
Cullen?
Yeah, just to throw out there that there actually is something in chapter 4117.035, which talks about individual public employees having the right to present grievances and have them adjusted, as well as without the intervention of the bargaining unit representative, as long as it's not inconsistent with the terms of the collective bargaining agreement. There is some very limited case law on this, where courts have essentially looked at whether or not the individual employee invoked the right of union representation at the onset of the grievance process. There's specifically, I can't remember the case, it's been a number of years, but where the individual basically was no longer happy with their union representative at the grievance step and wanted to use this language to come in with their own attorney. And the appeals court had said, no, you've already taken this through the bargaining the process as set forth in the contract. So you can no longer avail yourself of this language. So there's not a clear standard of when that necessarily begins, but there is a statutory right that has yet to be further kind of delineated as far as standards.
So it's a little bit of a choose your own adventure. Like once you start down a path, you don't get to go backwards.
Absolutely. That's a great way to put it. Yes.
And that probably makes some sense. Otherwise, you could imagine the sort of the relitigating the same things, getting almost there and then backing up multiple times. Because no one's happy on the day before an arbitration. And no one is happy really the day before you get a decision for an arbitration, I don't think. Just my experience, like everyone gets all kind of amped up right at the start. I think
I'm going to circle back to the one issue with the member who's being interviewed. I mean, as a witness. So you have a bargaining member being interviewed as a witness to an incident. Most collective bargaining agreements have that, well, policies for employers have some sort of rule that says that you're obligated to report incidents. And a failure to report can also lead to discipline.
correct.
So for those instances, would it be better practice for management to have have a union rep for that witness during an investigation?
I think it depends. And it depends on relationships, because anytime you're doing an investigation, it so much depends on relationships. I will tell you that in 15 years of being a management side attorney, I don't know that I've ever seen an hourly employee disciplined for not reporting just a policy violation. Now, if it's a healthcare abuse and neglect, oh yeah, no. If you have an affirmative obligation, you're a mandatory reporter, I think that's different. But to say that you witnessed that harassment and didn't report it, I've not seen discipline come out of that for hourly folks. For supervisors, 100%, right? But supervisors we're less concerned about. I think that if you can take an issue off the table, if you can take an argument away by allowing the union to be there and it's not going to impede the investigation, then it probably makes some sense to do so. I work with oodles of union folks that they can come to any meeting I have with an hourly employee any day of the week, twice on Sunday, I don't care. I also work with a couple of union folks that if they stay in another state, I'm going to be happier about that, because they won't, like, they'll argue with me about what my own name is. And I can't do an investigation if you're going to argue with me about what my name is. But if you have that kind of relationship that all of us are striving to get to between management and union, where we recognize that this is a relationship from which there is no divorce and we should figure out how to live together. If you have that, then you're taking that argument off the table that the union wasn't allowed in. I have also, it is amazing to me, and if you on the union side have experienced this, please know that my heart broke for you when it happened. But when employees are being interviewed and they just start spontaneously confessing all of their sins, everything they've ever done, like it's Chunk from Goonies, and you're like, wow. If the union's there, then you can ask follow-up questions about that. If the union's not there, you have to stop, right? And maybe see if they need union representation. I mean, do you have to? No, it's they need to invoke their rights. But if you've started by saying you were just a witness, you were not in trouble, like you can see how quickly that fact pattern gets confused. And if the union is just there, then I can ask the follow-up questions to the things that have just been confessed to, which happens an alarming number of times.
What happens when the management supervisor says, this is not an investigation leading to discipline?
Then it can't lead to discipline.
But it turns out it leads to discipline.
It can't, right? So I have used that in investigations before, but when I do it, I know going into it, I don't care what they say about the questions that I'm asking, it's not going to lead to discipline. So you need to be very careful when you give somebody comfort in that way, saying, don't worry, this cannot lead to discipline. Because if you say that and then try to discipline the employee, I mean, you're an arbitrator, Mita, right? Aren't you just tossing that right out and be like, nope, you told him it couldn't lead to discipline.
But it comes up because when you're in your scenario, when you're breaking them in about one thing and having a conversation, they're spilling their guts on everything else. But your premise was this will not lead to discipline. And then all
You need
that
to
stuff comes out.
You need to press stop. All right, I'm going to end this meeting. Right, it's that we've all seen A Few Good Men. I have, if you haven't, I'm not even going to say you should go watch it, but there's that moment when, you know, I'm going to tell the witness to stop test. He has Article 7 rights, whatever it, you all know what I'm talking about. I think in a witness interview, you would meet, all right, we're going to stop now. Do you want to bring in your union representation? We can schedule this for another time because now we need to have a conversation about what you've just said to me. I think you have to stop. If somebody just says something to you and you're not asking questions and it's off topic from what the interview is supposed to be about, I think you can press pause and you can bring in the union. But you have to have someone who's trained to recognize the moment and to not take that next step, which can be hard depending on who's conducting the interview, I think. And then, of course, all of that gets more complicated and confused anytime you're dealing with anything that could even come close to touching upon criminal violations. Right, Mike, you talked about it earlier. When we might want private counsel there if there's criminal stuff at play, and it comes up a lot. I'm actually seeing it more frequently. I used to primarily see Garrity when I was dealing with, you know, law enforcement. And I'm seeing Garrity and criminal issues coming up out of the woodwork. People were trapped at home for 18 months and got some interesting habits. So making sure that employers, that employees understand Garrity, that if we're going to compel an employee to answer our questions, their answers cannot be used against them criminally.
Kat, can you share some of those, examples that you've seen or heard of recently that don't involve the law enforcement employees?
Yeah, I've seen prostitution rings being run out of a factory. Lots of drug dealing going on. I've seen a lot of homebrew kind of cases going on. Harassment cases where you find out that our statutory rape laws have been violated. Like, it's just really, people are fascinating creatures. But there's just, and it bubbles up. And if you deal with law enforcement, Garrity is just, that's part of your vocabulary. It doesn't even matter what's at issue. We're talking about a uniform violation, but by God, I'm going to give you your Garrity notice and it's going to be in writing and it's going to be witnessed and maybe notarized. But streets and utilities, maybe not, right? They're not used to dealing with Garrity the way law enforcement is. And yet, if we're talking about someone who was dealing drugs at work or sharing their Xanax or sharing their girlfriend, right? There could be criminal stuff at issue that we need to think about, Garrity. Deb, did you have something?
No, I just wanted to say that my experience with Garrity stemmed from investigations I used to do regarding claims of excessive force, death in police custody or other claims of excessive force. And because they were compelled, I worked for a civilian investigative unit of the city manager's office. And because officers were compelled to come, it was called the notice to appear, which is the city's version of a subpoena. I would always read Garrity prior to starting the interview automatically.
Would you include Piper with Garrity? And this is truly, I've seen some jurisdictions, if they give Garrity, they tell people they have the right to counsel. And I have some people who give Garrity and they hold the right to counsel kind of off to the side and only use that in more formal situations. Did you?
Well, they'd always have the FOP, the police union with them. And the police union's council. So there'd be a rep from the union and the council, and I would just read Garrity. And I wouldn't really have to worry about, it would be between him, of course, him or her and the union, whether or not there would be some outside counsel at some point. But it was an automatic beginning to the interview process, because it was a condition of employment that they show up.
Right, if they're being compelled, the Fifth Amendment tells us that it's not going to be used against them criminally. How many people or have you seen? Most of my jurisdictions just give Garrity. At the start of the interview, they read Garrity just the way you did, Deb. And I've heard of a few that wait for the situation to arise, that wait for the employee to say Garrity or wait for the situation to arise. But I feel like that's the minority.
I would think so, because of the compulsion element of it. I would think so. I just know that it was our practice in the jurisdiction, well, the municipality that I worked for. It was just a given.
Yeah.
Well, Kat, with Garrity, those rights are automatic. I can see why, managers would be giving that automatic, as opposed to Weingarten, where it was you have to make the request.
There's actually a fascinating line of cases about whether Garrity needs to be invoked, whether it needs to be given, whether it just sort of appears when it appears.
Mm-hmm.
And I don't, if you love reading arcane case law, go forth. But there's different circuits view it differently. If you're in the state of California, they view it differently even still. So I think that a lot of employers have probably been given the advice of counsel of just give it, and then don't worry about it, because that is the easier option, where you don't have to get into whether it has been invoked or whether it just arises. I've even had the question, can it be waived? No, nope. You cannot waive the Constitution. That's not a thing. So it just gets a little tricky. We all know about Garrity, but diving into the details, like I do a lot of outside investigations. So I'm that outside agency, and I have someone from the municipality with me to give the order to talk to me, right? Because I can't compel anybody to do anything. Try though I may, right? But I need someone from the municipality to say, we have retained this human being to do this investigation. You are being compelled to answer these questions. And then they read Garrity and Piper. So. Does anyone have, does Garrity come up a lot for folks, or is it just a matter of course for everyone?
For us and our union representatives at the state of Ohio, most of the agencies I think that we deal with do not read it as a matter of process. I know DRC and APA do, but we train the delegates there to bring it up at the beginning of meetings like that. My experience though is that in those non-law enforcement type of agencies, so many times it throws the employer for such a loop that we end up sitting there for like 45 minutes while they make a call and figure out what's going on. I don't know the last time that I did one of those meetings was years ago, so maybe it's different now, but back then I just know that if it wasn't DRC, a lot of times they didn't know what Garrity was.
I think that's true. And even on the law enforcement side, like some of the fun questions that come out of it of, all right, I've got Garrity, can I still take the Fifth and refuse to answer this question? The answer is no. if I've given you Garrity and it's not a criminal case, you cannot refuse to answer my questions. You have to, which surprises some employees. I've also had the question of, well, does Garrity protect false statements? And it does not. So if the interviewee is a liar, liar, pants on fire, even if they have Garrity, they can still get in trouble
Okay.
for false statements.
Oops.
So
Okay, bye.
one of the other not fun, I say fun because I love my job, right? Recognizing that often what we're dealing with is life-changing for folks, but does Garrity apply to drug tests and breathalyzers? I think this is a ever expanding area. And generally, we say that the Fifth Amendment applies to statements, not physical evidence. But I've sometimes seen that of, you're compelling me to do this drug test, you're compelling me to take this breathalyzer, and Garrity. Garrity's not really to apply to that one. But it comes up in interesting ways, and I believe that for the next little while, we're going to see more of the issues in non-law enforcement venues, just because of the games that humans play and the shenanigans in which they engage. But I could be wrong. I actually hope I'm wrong. But, it's always surprising. And then, of course, the Piper. I said that we have to talk about Piper because I feel like Piper just gets ignored and it makes me sad. But there is a case out of 2000 that says that if you're in anything resembling that formal type administrative hearing, that an employee has the right to legal counsel. And it doesn't get a lot of play. I think the last time I checked, there were only 7 or 8 cases that really dug into what Piper meant and what was formal enough. And I think that's one of the tricky things. Like, when is an interview or an investigation formal enough that an employee has to be told that they have the right to counsel at that meeting? The Piper case itself was an employee being called to answer to a supervisor for issues. Well, what makes it formal? And a lot of times in the very few cases that we have, it seems to turn on what language is used by the employer when they send out the notice. If someone is being called to give testimony, if it's going to be recorded, if it's going to be used as part of an administrative proceeding later, then an employee has the right to counsel and should be told that they have the right to counsel. But it is so mushy about when you've crossed that line from, we're just having a conversation, or I'm just doing an internal investigation on harassment, into a formal process. That's why I've started just including Piper in my Garrity warning. There's just a paragraph in there that says you have the right to be represented by counsel. If we need to schedule this at such a time, we can. I just include it, and that might make me unusual. I don't know. I'd love to hear from some other folks about if they've ever had to deal with when Piper attaches and an employee has that right in an administrative or executive proceeding for legal counsel to be there.
And Kat, I apologize because I had actually a separate question related to that. But to me, when I hear legal counsel, that's it's a term of art. I mean, it means someone who's barred in the state. From my experience, a lot of labor unions may only have 1 or 2 actual general counsels or associate counsels on staff, but a lot of the representation is done through trained union representation. So what's the interplay with Piper here? Does that specifically mean legal counsel? So they have to get their general counsel down there if requested, or how do you see that working?
I would love to see that on the union side more often. Frankly, when this comes up for me, it is when it's Piper, it's on the law enforcement side. And here in Central Ohio, that means FOP Lodge 9. And FOP Lodge 9 has very established connections with law firms. So it doesn't come up that often because I know I'm usually going to see one of their legal counsel sitting across the table. I have not seen it come up where, well, I mean, other than at the arbitration where someone wants their own counsel and not union. And I don't know if our union advocates have had to deal with this where someone says, super great. I love the training that you went to in Las Vegas 2 years ago to learn to be a union advocate. But I would like to have a trained attorney here, and I have the right to do so. And that may depend in some cases on the union bylaws and constitution and who pays for what, because Piper does not say that you have a right to counsel paid for by your union. It says you have a right to counsel. And if you would like to bring your counsel, you can. Union advocates, have you all had to deal with this at all? This confirms my belief that I'm the only person in the state who cares about Piper. I think I just like saying the word Piper.
Does it specifically state though that it's going back to Colin's question? And I'm trying to think about it myself when you brought it up. As I think it just says counsel, not legal counsel. So the definition of counsel becomes into play, as it could just be an advocate advising you.
I think it's actually the word attorney.
Attorney.
I
Okay,
feel
so
like the statute says attorney. I'm not going to swear to that. But if you give me a minute, I can find out. While we're talking, go for it.
because I'm thinking that under Kat's example, she puts it in with her Garrity. So when that notice goes out saying that you're entitled to an attorney for this questioning, then I think the union has to send in an attorney. Or do they make them go out and get their own private attorney, and they only provide their, union rep?
It's the word attorney. So it is ORC section 9.84, witness has right of counsel, participation in hearing limited. And it's all of the lead up language, but it shall be permitted to be accompanied, represented, and advised by an attorney whose participation shall be limited to the protection of the rights of the witness. So they have a right. So my instinct would be is that where you have a union that does not have a baked in attorney process like FOP Lodge 9, that's a conversation that happens on the back end. Like, we, the union, can show up and represent you, and we have this wonderful person who's going to do that. Or if you would like to retain an attorney at your own expense and have them represent you at this hearing, you may do that instead. Which is why we maybe don't see a lot of it, because I would imagine a lot of employees who are dealing with an internal affairs investigation or a harassment investigation, something that's going to rise to that level of a formal process. Like, well, I pay union dues, so you union represent me. I'm not going to go hire a separate attorney at my own cost.
Some of your union advocates want to chime in on this? Linda, what is your thoughts?
As far as whether we would supply an attorney in that case, it would be exactly what Kat just said. But the issue has never been like raised under Piper. No one has said that. It's typically just the union member will say, I want an attorney, and then we say, kind of what we were talking about earlier, that's fine, but you have to choose. You can't have both of us.
Are there times, Amanda, where the issue is such that now we're going to go find outside counsel, we're going to find a specialist? So this contract interpretation is such a big deal that, and I mean, I've seen that from the steel workers. I mean, usually with the steel workers, it's going to be a staff rep, but on occasion, they send an attorney because the issue is political enough or hot.
Yeah, I haven't seen it personally, but I could imagine that being a possibility.
Yeah. Sure. But again, I think, like I said, I care about Piper, I think, more than other folks, but I'll just keep pounding the drum on that one, and we'll see what happens. We're nearly to our hour mark, Mita. Are the
Yes.
final thoughts or questions or for the good of the order of things?
Any last words from anybody? Well, I think we are due back on May 19th. And our facilitator at that time is Josh Norris.
And if y'all don't know Josh, I'm gonna go ahead and give a plug. Amazing human being, delightful. He's on the union side and I still find him delightful. Like, thumbs up there. So you should listen to him.
He's another good educator
Yes.
on this topic. So we also want to thank Kat for being our facilitator today. Applause to you. And everybody else, enjoy your day.
Thanks, y'all.
Thank you guys. Thanks, Kat.
Bye.